Hi, this is Lee from the Law School Toolbox and the Bar Exam Toolbox. Today we are talking about lawyers' duties when dealing with third parties. As we've mentioned in other Listen and Learn episodes on professional responsibility, this is a heavily tested area. You will take the MPRE, and if you are in California, it is very likely that you'll see professional responsibility on your written exam as well. Today, we will be talking about a lawyer's duty when interacting with third parties. A lot of the professional responsibility topics center around how lawyers interact with their clients, since the people that lawyers are serving are their clients. But lawyers also deal with opposing parties, courts, and other third parties, including the public at large. Today, we're going to focus on interactions with opposing parties. Let's start with a basic rule governing how lawyers interact with other people. Rule 4.1 of both the ABA and the California Rules of Professional Conduct prohibit a lawyer, in the course of representing their client, from knowingly making a false statement of material fact or law to a third person, or failing to disclose a material fact to a third person when disclosure is necessary to avoid assisting their client in a criminal or fraudulent act, but only if the disclosure would not violate the lawyer's duty of confidentiality. Now, keep in mind that this rule prohibits a lawyer from making false statements or representations, but it doesn't prohibit a lawyer from engaging in puffery or other statements that are not statements of material fact. This might include whether or not the lawyer's client would accept a settlement offer or suggesting a particular value of the case in the course of negotiations. Now let's look closer at the rules that apply when a lawyer interacts with the opposing party. We'll start with represented parties. Under both the ABA and California Rules of Professional Conduct, in the course of representing a client, a lawyer is prohibited from communicating directly or indirectly about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer, the communication is otherwise authorized by law or court order, or specific to the California rules, the communication is with a public official, board, committee, or body. If the other party is a represented corporation, partnership, association, or other private or governmental organization, the lawyer is prohibited from communicating with a current officer, director, partner, or managing agent of the organization, or a current employee, member, agent, or other constituent of the organization, if the subject of the communication is any act or omission of that person in connection with the matter which may be binding upon or imputed to the organization for purposes of civil or criminal liability. Now, this rule is not meant to prohibit a lawyer from having cordial conversations unrelated to the legal matter with the opposing party, but is instead meant to protect represented parties from interference with their lawyer-client relationship by other lawyers interested in the matter. That means that the rule applies even if the represented person initiates the contact. In that case, the lawyer must terminate the contact as soon as they obtain knowledge that the person is represented. And a lawyer cannot try to get around this rule by using an intermediary, such as an agent, investigator, or even the lawyer's client. On the other hand, the parties to the matter aren't prohibited from speaking to each other, and a lawyer is not prohibited from advising a client concerning a communication that the client is legally entitled to make. To see how this rule has appeared in the exam setting, let's review this hypothetical, which is based on a portion of the professional responsibility question that appeared on the July 2024 California bar exam. August is an attorney who represents Paul in a lawsuit against Paul's former real estate broker, Danny. With Paul's permission, August sent a written settlement demand for $500,000 to resolve all issues to Danny's lawyer, Len. Len did not respond to the demand and did not communicate the demand to Danny. One evening, Paul saw Danny at a restaurant and asked her about the settlement demand. Danny told Paul that she had no knowledge of the settlement demand. Paul then told August about his conversation with Danny. At August's request, Paul contacted Danny, communicated the settlement demand, and explained why $500,000 was a good offer. So we're only going to focus on August here, even though you probably spotted some issues with what Len, Danny's lawyer, did, or really didn't do as well. Since Danny is represented by Len in Paul's lawsuit against her, August is prohibited from communicating with Danny about the matter. So even though August knows that Len hasn't told Danny about the settlement demand, August could not reach out to Danny and communicate the settlement himself. That brings us to Paul's communications with Danny. Since Paul and Danny are the parties in the lawsuit, it was perfectly fine that Paul asked Danny about the settlement demand when he saw her at the restaurant. But what about Paul's second contact with Danny? The facts tell us that August requested that Paul communicate with Danny about the settlement demand. Remember that the rule prohibits the lawyer from communicating both directly and indirectly with a represented person, including through the lawyer's own client. Since August specifically requested that Paul talk to Danny about the settlement offer, it is reasonable to conclude that August was trying to communicate with Danny, a represented opposing party, indirectly through his client. Thus, it was an ethical violation for August to communicate with Danny via Paul. Now let's modify the facts a little bit and see how the application changes. Paul told August about his conversation with Danny at the restaurant and asked August whether Paul could tell Danny the details of the settlement demand. August told Paul that it is not advisable to discuss the details of the case with Danny, but that Paul would not get into any trouble if he decided to do so. A few days later, Paul reached out to Danny and communicated the settlement demand and explained why $500,000 was a good offer. So here, August provided advice to Paul about whether or not Paul should discuss the case directly with Danny. But he did not ask or direct Paul to talk to Danny about the case. August is allowed to advise his client on the benefits or detriments of talking to the opposing party about the matter. And since the parties to the matter are allowed to talk to each other, Paul's communication with Danny about the settlement demand in this modified fact pattern was fine. Now that we've talked about communicating with represented parties, let's talk about a lawyer's duties when communicating with unrepresented parties. The ABA rule and California rule regarding communicating with an unrepresented person prohibit a lawyer in dealing with an unrepresented person on behalf of a client from stating or implying that the lawyer is disinterested in the matter. If the lawyer knows or reasonably should know that the unrepresented person misunderstands the lawyer's role in the matter, the lawyer must make reasonable efforts to correct the misunderstanding. The lawyer is also prohibited from giving legal advice to an unrepresented person, other than the advice to secure counsel, if the lawyer knows or reasonably should know that the interests of the unrepresented person are, or have a reasonable possibility of being, in conflict with the interests of the client. The California rule also prohibits the lawyer from seeking to obtain privileged or other confidential information if the lawyer knows or reasonably should know the unrepresented person may not reveal without violating a duty to another, or which the lawyer is not otherwise entitled to receive. So let's revisit the August, Paul, and Danny fact pattern here, but with a few modifications to apply this rule. August is an attorney who represents Paul in a lawsuit against Paul's former real estate broker, Danny, but this time Danny is unrepresented. With Paul's permission, August sent a written settlement demand to Danny for $500,000 to resolve all issues in the matter. After receiving the settlement demand, Danny called August to discuss it. During the phone call, Danny said to August, "I'm not a lawyer, so I really have to trust your judgment here. I just want this resolved as quickly as possible." In response, August told Danny that he just wanted the best possible outcome for both Paul and Danny. August also advised Danny that she would almost certainly lose if she took the lawsuit to trial, so she should agree to the settlement demand. Now, here we have August dealing directly with Danny, but since she is unrepresented, this is not a problem on its own. A lawyer who is dealing with an unrepresented opposing party will naturally need to communicate with that party about the case. However, August's statement that he wants the best possible outcome for both of the parties implies that he is disinterested in the matter, which is not the case. August's interests are aligned with Paul's here because Paul is August's client. Danny's statement during the phone call that she is trusting August and that she just wants to get the matter resolved quickly also indicates that Danny does not understand that August's role in the matter is to advocate for Paul's best interests. August reasonably should have known that Danny misunderstood August's role in the matter, and he should have clarified for Danny that he was representing Paul, not Danny. Also, August's comment that Danny should accept the settlement demand because she would almost certainly lose if she took the lawsuit to trial constitutes legal advice because the determination of whether to accept a settlement or proceed to trial necessarily involves an evaluation of the merits of each party's case. August also knew, or reasonably should have known, that Danny's interests are in conflict with the interests of Paul, because Danny's interest is in settling the lawsuit for as little as possible, and Paul's interest is in settling for as much as possible. Thus, August was prohibited from giving Danny legal advice except to advise her to retain her own counsel. Finally, the first rule we discussed in this episode, that a lawyer must not knowingly make a false statement of material fact or law to a third person, could also apply to August's statements to Danny. While August is allowed to engage in puffery in his negotiations with Danny, he can't misrepresent material facts or make a false statement of law. We don't know how truthful August's statement to Danny was about her chances of winning a trial, but August's statement that he only wants the best possible outcome for both Paul and Danny is clearly a material statement of fact, since it was intended to persuade Danny to accept the settlement. The remaining issue is whether the statement was false. August might actually want the best possible outcome for both the parties, but his professional duty is actually to Paul, so the exam taker could conclude either way here. Well, that's all that we have for you today. We hope you found these hypotheticals to be helpful examples of how to work through a question involving these rules governing a lawyer's duty to third parties. Thanks for watching, and be sure to give us a like, leave a comment, and subscribe so you don't miss any future content.